goes by, this is a public service on YouTube.
I think I'm all set again.
This is a public service.
This is a public service.
Just for record, you set up some devices. I'm assuming those are recording devices.
That's correct.
You've not brought a court reporter with you. It's fine. You can have the recording devices are fine. I just wanted to make sure that that's what they were.
Yes.
Thank you. All right, if everyone's ready, I'm just going to take a moment and go over the proceedings. First of all, we're here to hear the appeal of the trespass warning issued to Joshua Gray, number 2025-TP-003875. Following my opening, I'm going to try to give an idea of what the proceedings will look like procedurally so everyone knows what to expect this morning. First of all, my name is Amy Goodblatt. I'm the special magistrate. We'll be hearing this trespass warning this morning. Following my opening remarks, we will swear in the witnesses, so anyone who anticipates giving any testimony today, we'll all stand and we'll swear everyone in as witnesses. If anyone comes in late, we can swear them in later. If you're not sure if you're going to give testimony, probably a good idea just to stand up so we don't have to stop down after every person gives testimony. Once I do that, I will ask each of the parties, you have the option, not the requirement, if you would like to present in summary form initially, for up to about no more than 10 minutes, a summary of your argument here today. Typically that would be the appellant first, then the appellee, the city second, but you could choose to waive that and just jump into your evidence. It would be at the beginning of your case, so if the appellant would go first, the city has the right then also to make a statement, or the city could wait till the beginning of its case as it chooses, or waive that right as well. Following those openings, we will then ask the appellant to begin by calling any witnesses that you may have, following the testimony and introduction and testimony of each witness, introduction of any exhibits. There'll be cross-examination by the city if there is any. I will also possibly ask some questions, maybe, maybe not, depending. Once the appellant will have presented all of its witnesses and all of its evidence, the city will be afforded the same opportunity, and the appellant, you'll be given the opportunity, Mr. Gray, to ask any questions you want of the city's witnesses that fall in the nature of cross-examination. These proceedings are quasi-judicial proceedings, meaning that the rules of evidence do loosely apply. They apply, but it's not as rigid as being in a courtroom, but things like relevance, hearsay, and so forth are legitimate objections during the proceeding, but we are a little bit more relaxed in terms of how we proceed in accordance with the ordinance. Following the conclusion of all the testimony today and the presentation of evidence, there will be a ruling that will come in writing from my office in conformance with the ordinance within 5 business days. We are scheduled to be here no longer than 3 hours. If there are any lengthy exhibits that would take up more time than that, I may have to take it under advisement so that I can review them. I can't watch an 8-hour video if that were to be submitted to evidence during a 3-hour hearing, but we'll try to approximately share time between both sides equally. I'm not going to run an egg timer on anyone, but so that neither side overwhelms everyone with time. So I'll try to keep an eye loosely on those things. Okay, at this time, I'm going to ask that anyone who anticipates giving any testimony today, that you stand and raise your right hand.
Is what I'm doing testimony?
If you're going to present evidence and talk about what I'm probably, I
So
can't say.
is he not doing that?
He's acting as an attorney, so he'll be calling witnesses to give testimony, but I assume you're going to be a witness in your own case.
Well, I'm not sure how I would call myself.
Then, well, I can't give you legal advice, but if you're unsure, it doesn't hurt to get sworn in. If you're uncomfortable with that, you don't have to, but then obviously your testimony won't be under oath. So it is, if you say this is what happened because I was there, then that's testimony.
Sure.
Okay. You solemnly swear oath or affirm the testimony you will give today will be the truth and the whole truth.
I do.
Yes, very much. Okay, at this time, I'm going to ask if you would like, Mr. Gray, if you're not required to present a summary of, but this isn't all your evidence, a summary of what your legal arguments would be today, if you want to do that. And again, as I said, probably no more than 10 minutes. If you want to waive that right, that's up to you.
I can waive that right. I don't think it's necessary. I'll be quite redundant if I give a statement and then directly go into the evidence that covers that statement, basically. So I'll waive that. So I'll just begin, I suppose.
Let me ask the city if it wants to make an opening statement.
I would.
Mr. Langley?
Good morning. Thank you for your time, Your Honor. On September 4th,
2025, Mr. Joshua Gray arrived at the Longwood Police Department lobby with the intention of violating Ordinance 25-2266 and with the intention of confronting law enforcement personnel regarding the prohibition of video and audio recording within the Longwood Police Department lobby. The City Commission adopted Ordinance number 25-2266 earlier this year. Mr. Gray was aware of such ordinance, was aware of the prohibition, and Mr. Gray was recording his interactions on September 4th, 2025 on his smartphone, live streaming them to his YouTube channel, and later posted an edited version of that recording on YouTube. His channel is called This Is a Public Service. His own video that he posted 100% shows that he violated the city's ordinance. There should be no dispute about that. Mr. Gray, in fact, with prior knowledge of the prohibition of recording and video and audio within the PD lobby, willfully and knowingly violated such ordinance. And the posted sign on the door of the lobby of the police department that clearly indicated to the public that a person is not allowed to video and audio record within the police department lobby. He did so anyway. The evidence shows that clear and convincingly that he violated the ordinance. Sergeant Gelm with the Longwood Police Department followed standard protocol and lawfully issued a trespass warning to Mr. Gray for violating the ordinance. This appeal has no merit. I want to just briefly talk about our ordinance that's at issue, 25-2266. It codified into City Code Section 2-2, which expressly states that it's expressly prohibited to record video and audio within the lobby of the police department, Longwood Police Department, or any restricted areas of Longwood Police Department building. Subsection E says, quote, anyone observed to be recording video and audio within the city-owned, controlled, or leased property in violation of this section 2, which is 2-2, who refuses to cease recording activity after being advised such activity is prohibited under this section, shall be considered to be a disruption to the work of the city government. Such person shall be deemed no longer present within the city-owned, controlled, or leased property on legitimate public business. Anyone who refuses to cease video or audio recording or who refuses to immediately leave the premises upon request shall be considered a trespasser. Law enforcement, at its option, may enforce the person's refusal to depart by issuing a trespass warning for this conduct. Additionally, subsection F provides that it is that the city manager or his or her designees have the right to remove any person who acts in a manner which violates any city rule or policy or any directive on any sign or notice at public property. And this violation can be enforced by law enforcement by issuing a trespass warning. So, Your Honor, again, the ordinance speaks very plainly. There's no requirement in the ordinance that the officer that issues a trespass warning know with 100% certainty that one is recording at the time. It's a matter of observing whether there's recording activity happening by the conduct, the statements, the activity that's arising during the incident. And when one is told to cease that observed activity and fails to do so, a trespass warning is appropriate. Thank you.
Okay, Mr. Gray, if you'd like to call your first witness.
I'd like to call the chief, Chief Dowda.
We're going to use that chair over there as a witness stand, sir.
Good morning. David Dowda, Chief of Police.
Morning, Chief. Chief, you didn't write this ordinance, correct?
Write it? No, sir.
But you did present it to the city council, is that correct?
I did present the agenda item. Yes, sir.
So would you say that you're pretty well versed on the ordinance?
Pretty well.
Pretty well. We're just going to take a look at the ordinance. We're going to go, I'd like to admit the ordinance into evidence.
I'll take judicial notice of the ordinance because it's common. Thank you for it's in evidence.
Chief,
Would you mind if I have a copy of it? May I?
Oh, if you want a paper
Have it.
copy, sure. I also have one, but sure, if you want a paper copy. Because it's also up on the screens too. So Mr. Langley, you okay? You have another one with you? You just gave up your copy.
I don't need that, but thank you.
I also have it electronically too, so I could give up my copy. if need be. No, I've got one. And here, up there, I'm good. Thank you.
Okay, so we're going to actually we're going to dissect this piece by piece. A phenomenon has developed in recent years in which people make video and audio recordings of public employees in public spaces under the auspices of First Amendment auditing.
Is that a question? He waived opening argument, not that this was question time.
So let me just give some general guidance here, because these are the rules of evidence. When you ask a witness questions, when a witness testifies, you must ask them a question so they can respond to it. You can read a portion and ask a question about that portion, but I can't give you legal advice, but yeah, this is a question and answer, so I'll sustain the objection.
So,
phrase that as a question.
Yeah, I wasn't finished.
We didn't send you to law school.
Yeah. I wasn't finished when he objected. But I just so you know, and maybe this will frame his objections moving forward, I'm going to read each one of these whereas, and then I'm going to ask a question. Okay, so if Mr. Langley would allow me, or I can have the chief read them to us, but maybe that's the way we should do it. I have the chief read it so I don't get objected to by Mr. Langley.
Your Honor, if I may.
Certainly.
I object to that. I mean, the ordinance speaks for itself. You obviously can read the ordinance.
Well, that's the thing.
The chief is not here to testify on legal conclusions. Mr. Gray can ask him questions that are relevant to facts that the chief may have knowledge to. But if he's eliciting legal advice or legal speculation from the chief, that's not appropriate. But of course, I don't know everything he's going to ask
I'm going to
you.
overrule the objection because I haven't heard the question yet. So if it's going to be the same question as to each subsection, I'd have to hear the question. I can't rule. So I'm going to overrule the objection for now. You can ask your question, and I don't know, Mr. Gray, you have if it's going to be a different question on each subsection, that's fine. If it's going to be the same question.
It's not. It's different questions.
Okay.
It pertains to each subsection, the question.
The same question to each subsection? No.
Each subsection is going to contain a question that is not repeated.
So why don't you go ahead and ask your question?
Thank you very much.
First subsection. I don't know that you can also not read it in the record. It's the first whereas clause if we want to do that to save some time. Or we could read it in. That's fine.
I mean, again, I'm not going to be playing videos, so I don't see us getting anywhere near this 3 hours unless Mr. Langley wants to play my videos, which I'm happy to have them on the record. It makes no difference to me. Chief, is anybody that comes into the public lobby at the police station there filming, are they classified as a First Amendment auditor?
No.
No. Is the press allowed to come into the lobby and conduct business?
Conduct business?
Yes.
Yes.
Did you watch the body cam from Sergeant Gelm?
I watched portions of it.
Was was Mr. Gray in the lobby to conduct legitimate business?
I don't know what you mean.
Are you, isn't it true that Mr. Gray was in the lobby to submit a public records request?
That was vocalized by you on the audio.
Is that official business?
Yes.
We're going to move on to the next whereas. Whereas, you have it in front of you. Could you read the second whereas? Whereas it's currently settled law.
Whereas it is currently settled law that there typically is a right under the First Amendment to record the activities of public officials on public property. But like all First Amendment protections, this right is subject to reasonable time, manner, and place restrictions. See the case of Smith v. City of Cumming, 212 F3D 1332, 11th Circuit 2000. And
Are you familiar with that case?
no,
You're not
I read
familiar?
it at the time, but I couldn't quote it
So
to you now.
the case that involves filming police activity, you're not familiar with.
I was familiar at the time that
When was this ordinance presented to City Council?
earlier this year, April.
April. Were you familiar in April?
Yes, I read the case at that time.
So in April you were familiar, but now in October you are unfamiliar. Am I to understand that
I could
correctly?
not speak specifically about that case. I haven't read it since. that
Do the
time.
people have a First Amendment protected liberty interest in keeping a watchful eye over government?
To the question, again, this is requesting legal conclusions.
It goes directly to the ordinance. We're literally.
Question for me, please.
Do the people have a First Amendment protected liberty interest in keeping a watchful eye over government?
I would sustain the objection because I believe it's beyond the scope. It hasn't been established that this witness has any expertise in that area. He's police chief. I don't know that it was established he's a legal expert and so forth.
Okay. Is it a clearly established right to be able to film the police in the course of their duties?
Same objection.
This is settled law. I mean, if the chief doesn't know, we're in trouble.
I'm going to sustain the objection. I still believe that he's not been qualified as an expert in the law behind the ordinance and so on and so forth. He's got certain duties, but it hasn't been established that that's his expertise, knowledge, and so forth.
When you presented this ordinance to the council, did you present it as an expert?
No,
What did you present it as?
it was the chief of police presenting an ordinance.
And why were you presenting it?
Why was I presenting it?
Yes, why were you presenting it?
It pertained to the police department's lobby.
Yeah. Specifically, what was the issue that Chief Dowda had?
Objection, ambiguous question.
Chief Dowda was presenting this to City Council, and he seems confused as to why he was even there.
I'm not sure it's relevant to whether there was a violation of the ordinance, why he presented something to the city commission back in April. If you can give me an insight.
I guess what I'm saying is that he presented something to the City Council that is a blatant and clear violation of not only his oath to the Constitution, but to serve the people of the community in a transparent and accountable way.
If you want to ask questions about what he did in the course of his duties pertaining to this particular warrant and its issuance, that's fine. The creation of the ordinance is not, we're here on appeal of this particular warrant. He's not on trial here, so the issue for today is whether there's a violation of the trespass warrant. If your indication is that it's unconstitutional or was unconstitutionally applied to you, I don't know that this witness is an expert in that and can give that kind of testimony. And his motive in presenting it, he didn't make it the law. It was the city commission that made it law.
He presented it
Right.
to the City Commission in order to get it approved. Is that correct, Chief Dowda?
I presented it, yes, sir.
You presented it, but you have no knowledge of what's inside it. Is that correct?
No, that's not correct.
Are you familiar with the case Smith versus the City of Cumming?
Objection asked and answered.
The answer was no. He's not familiar, just to be clear. All right, let's move on to the next whereas, Chief. Whereas the law generally allows.
Whereas the law generally allows for the use of audio and recording devices in public access areas of public buildings, but not in restricted areas that are not generally open to the public or not open to the public without escort and.
The law generally allows for the use of audio and video recording devices in public access areas of public buildings, but not in restricted areas. Was I ever in a restricted area? Over at the police department on, what was the date we were referencing? The 14th or the 15th, whichever day we're here about.
You were not in a restricted area, as I would classify them. But
Is
you were
it
conducting
generally-
business in an area that restricted you from that area?
Chief, that doesn't make any sense. Could
You
you
were
rephrase that?
Let
Your
me finish the
activity-
answer to the question.
Well, he stopped, to be clear.
I'm sorry?
Could you repeat the answer?
You were filming in an area where you were restricted from filming.
Was I ever in an area of the building that was restricted to the public?
To the public, no.
Do the-
Public recording, yes.
Are you aware that the press and the public have the same access to public property?
Objection, calls for legal conclusion, and it's not relevant.
Sustained.
It's not relevant that the people and the press have the same rights?
It's not in the scope of knowledge of this witness. He's not brought in as a
The-
legal expert.
The chief isn't aware of the citizens' press rights that he swore to protect? Chief, are you not aware of the press rights that you swore to protect?
Objection, legal conclusion, irrelevant, beyond the scope of this hearing.
I would say it goes to the heart of everything that is happening at this hearing.
I don't know that I don't know that it's been established that the chief was sworn to protect the rights of the press.
It's the First Amendment, miss.
It's different.
No, it's freedom of press.
So I've ruled on the objection and proceed to the next question.
Chief Dowda, did you swear to protect the residents' freedom of press rights?
Same objection, asked and answered, and over the objection before was.
Clearly, it's not the same question if I had to rephrase it.
Let me answer the question. I'll overrule the objection for the time being. But please do keep in mind that this witness is not a legal expert, has not been qualified as a legal expert as a police chief. A little bit different scope of evidence, and also remember relevance to the issue here, which is the appeal of the warrant.
The appeal of the trespass. There's no warrant.
I didn't mean warrant. Trespass warning. Excuse me.
Thank you, Your Honor.
I swore an oath to uphold the Constitution of the United States of America, the Constitution of Florida, and the laws and ordinances of the city of Longwood.
Could you just answer the question that I asked you and not some other question that I haven't asked yet? I was asking about freedom of press rights, if you remember.
I believe I answered that question, sir.
Did you swear an oath to protect all of the people's press rights?
I swore an oath. to
It's a yes
protect
or a
the
no.
Constitution of
Your
the
Honor,
United States
it's a
of
yes or a
America.
no, Your Honor.
He's answering the question the best he can within the confines of his ability and his knowledge of the law, so I'm going to let him answer stand.
It's pretty scary. Go ahead.
I think he's answered the question. Have you completed your answer?
Yes, ma'am.
Move on.
If we could move on to the next one, Chief.
Whereas it is by now clear the First Amendment does not guarantee access to property just because it is owned by the government. Blowdorn v. Grube.
All right, that's good. Are you familiar with that case?
Somewhat, yes, sir.
Do you know what it involved?
Somewhat, yes, sir.
Could you tell me what it involved, Chief?
Objection, this is irrelevant and calls for
This is
a legal summary of a case that's not relevant.
This is literally listed in the ordinance that we're here talking about.
It's not
All right.
listed in the trespass warning that you
Did I
issued.
interrupt you?
You've been interrupting the witness the whole time.
I've been interrupting the witness the whole time. Interesting.
Everybody, let's just keep it. So it's been, it has not been yet established that the police chief is here in any role as an expert in legal matters. Presenting an ordinance doesn't qualify him as an expert. So asking him about case law and statutes isn't really testimony. The case speaks for itself. I'm going to make a ruling. I can read it. You can talk about it in your argument or in your opening or your closing, and you can discuss the case with me because I'm aware that it's in the ordinance. It's fair game. But I don't know that I don't know that it's relevant to this proceeding that the police chief testify as to the substance of that case.
Sure. When you presented this to City Council, Chief, if the City Council had any clarifying questions about any of these whereas, would they ask you?
They could.
Okay, so that's what I'm here doing. I'm just asking these same clarifying questions to get a sense of if you know what the hell you're talking about. So that's what I'm here for.
Sir, I'm going to ask that everyone treat each other professionally and that the language, what the hell we're talking about, would not be considered appropriate language for a courtroom. So I'm going to ask that everybody give their language.
It is protected speech, though.
Whether it is or it isn't, the word hell doesn't really belong. There's no reason for that to be introduced. Please keep the language clean. Thank you.
Okay, I just want to point out it's protected speech.
Correct. I heard your point.
Okay, so is it safe to assume that you don't know what Blodorn versus Grube addressed?
I think I answered that question. To your question about...
That's the only question on the table right now, Chief. I've asked a question. I didn't ask him to answer past questions. I asked a question about Blodorn versus Grube, nothing else. Please, Chief.
I was very familiar with it at the time. I'm somewhat familiar with it now.
Somewhat at the time, very. Okay. Do you know if that case involved expressive activity or non-expressive activity?
I don't recall.
Is holding a camera expressive activity or non-expressive activity?
Objection.
Why are you looking at the attorney?
Your Honor,
He was about to speak.
I was.
Sir,
Sweet.
Your Honor,
he had his mouth open, so I can't be commenting on the actions of everyone here. Please, everyone.
I can.
No, these are questions and answers and presentations. City Attorney wants to be recognized. Sir.
Your Honor, thank you. So same objection. We're continuing to ask questions about cases that are in the ordinance. The ordinance speaks for itself. The cases speak for themselves. It's not proper testimony for a witness. Even if there was a legal person certified as a legal expert, that's not appropriate factual testimony because Your Honor is the one making decisions on law, and I would say that's not even relevant to the issue in this proceeding, which is, was the trespass warning properly issued or not? That's it.
Constitutionality, so let me weigh this on the ordinance is something you're entitled to argue, Mr. Gray. No worries there. I'm not, but you have to appropriate witnesses to do that, or you may argue it just based on the law. You can present case law. You don't have to have a witness come in and testify. You can show me case law as part of your evidence, but I don't think asking witnesses who are not legal experts, have not been qualified as legal experts to opine on those things is appropriate, and it's not relevant. But you do have the right, obviously, to provide me case law and testimony on case law that says, no, this ordinance is not constitutional.
Sure.
Not to a witness who is
I've got a bunch of case law.
Doesn't have legal background that way.
Sure, I've got a bunch of case law we can get to when the time is appropriate. Okay, we'll move on to the next one. It was expressive activity. That was the answer to the question, Chief. Whereas.
You'd like me to read the next?
Yes,
Whereas,
yes, we're going to do the whole thing, Chief.
Whereas restrictions on Limited public forum need only be 1, reasonable, and 2, viewpoint neutral. Sheets v. City of Punta Gorda, Florida.
And did you read that Sheets decision?
I did.
Are you familiar with it today?
Yes. Somewhat.
Somewhat. Are you familiar with the ordinance that was in Punta Gorda about filming?
I am not.
So you're familiar with the ruling around what happened in Punta Gorda, but you're not familiar with the ordinance in Punta Gorda? I just want to understand that correctly.
You understand it correctly.
Are you aware that the ordinance in the city of Punta Gorda actually affirmed the right to film?
I am not.
If I could admit let me pull up the exhibit. I think it's called Chapter 15, Offenses and Miscellaneous Provisions.
Is that one of the exhibits you provided this morning?
It is, yes.
What,
Now, I didn't make copies of it, but I can bring it up on my iPad and I can hand it to the chief if that's helpful.
I have it on my iPad, so I just pulled it up myself. I think the city may have it. I don't know if the city's brought that with them.
Well, I kind of did that last minute too, yes.
I have a copy of it. I'm objecting to its admission into evidence as irrelevant. It's not even an ordinance at issue in this case.
I couldn't tell where it was. Can you give me some background on that piece of it?
Yes, I can.
Like, what is the,
So it's on page 15-31 of
what
the.
is that ordinance? It's from,
It's the city of Punta Gorda. It was the ordinance that Longwood based their ordinance on. Actually, Longwood didn't base their ordinance on the ordinance. They based it on the ruling. I don't think they even took the time to read the ordinance, which would have been the smart thing to do, since Punta Gorda actually points out that you have a right to film, but it's about consent in the public areas. I think the chief just.
so that would be the 15. I can take judicial notice of it, and whatever weight I give it will be whatever weight I give it in terms of, but yes, I'll admit it, take judicial notice of the ordinance of the city of Punta Gorda.
Okay, very good. Are you aware if Mr. Sheets argued that the ordinance was prior restraint?
I'm not aware.
Are you aware if the ordinance penalized unconsented recording?
I'm not aware.
Are you aware if you could film as long as you had consent?
No.
So it's safe to say that you're unfamiliar with the ordinance in Punta Gorda?
That's already been asked and answered.
I asked about the Sheets ruling, I thought. I could be wrong, but
I think you also asked about the ordinance.
I could have. Let's, just for the sake of clarity, though.
I did answer you.
What was that answer?
Can you repeat the question?
Are you familiar with the ordinance in Punta Gorda, not the Sheets decision?
I am not familiar with the ordinance.
Thank you very much. So are you aware that the Punta Gorda ordinance actually affirmed the right to film?
Objection. This is, again, asking for speculation about something the witness already said he doesn't have knowledge about a code, and again, it calls for a legal conclusion, not appropriate relevance.
Thank you, Your Honor. Or Magistrate, I'm sorry. Your Honor? Can we go that way?
I don't, you can call me Ms. Goodblatt, call me Ron, you can call me her magistrate, whatever you want to call me, that's fine. Ms. Goodblatt's fine too.
All right, thank
I'm not
you.
hung up on the title today.
Thank you, Her Magistrate. That just seems more.
No, you can call me Ms. Goodblatt too. I'm not hung up on the title.
All right, thank you. All right, Chief, I think that we've established that you weren't super familiar with the Punta Gorda ordinance when you presented this to the commission. If we could move on to the next one, whereas there are portions.
Whereas there are portions of City Hall, the police department, and other public buildings which are restricted or generally not open to the public without escort. And
Was I ever in one of those areas? Was I ever in a restricted area, restricted to the public?
you are not in an area restricted to the public.
Thank you. Could we move on to the next one?
From the public.
Could we move on to the next one?
Whereas the presence of the public in such restricted areas, including for the purposes of video and audio recording, is disruptive and detrimental to the safety, welfare, and performance of the duties of the city employees. And
how is it disruptive?
filming in the lobby,
Yes.
it is disruptive in the sense that there are people there sharing at times personal information that can be recorded and then shared inappropriately with others.
Do you have any examples of that ever happening? Ever? Once?
Being shared with the public, I do not have an example of that, but we have had incidents where
We don't need to answer questions I haven't
And he can
asked.
finish his answer to the question.
Sure.
Complete your answer, sir, please.
We had an incident where someone was recording in the lobby. A young lady walked directly up to the clerk, in the reception area. She made a comment about a very private matter, not realizing that someone was recording.
Do you have a reasonable expectation of privacy in the public lobby?
Yes, sir.
Yes, you do. Could you cite any relevant case law?
Objection to that question. It calls for a legal conclusion. It's not relevant.
He gave the legal conclusion. I'm asking him to properly frame it within the law.
I'm sustaining the objection. He's not qualified, and he has not given any testimony yet. He's legal training, legal expertise in that area. He's enforcing a law. So I'm going to sustain the objection.
Chief, did you just assert that you have privacy rights in public?
Yes.
What would lead you to that conclusion?
I attended a training with one of the city's attorneys at a PRM conference where the subject was covered. That attorney trained me that person has a reasonable expectation of privacy in the police department's lobby.
And again, is there any relevant case law, or is that just something somebody told you?
It is a training that I received at a public risk management training from the city's attorney.
Just for clarity, is that a no?
He's answered the question.
But he didn't answer the question. He said he went to a training, but I go to trainings all the time.
There's an attorney who gave information. So he's answered the question to my satisfaction. Thank you.
Interesting. Okay.
Sir, I know you're not a lawyer, so I'm trying not to hold you to the same standard, but commenting on each answer or each objection or each ruling is not appropriate. So
I'm not a trained lawyer. It's how I internalize
understand,
my
but I'm
thoughts.
asking you to refrain.
I'll try.
You can make little notes to yourself.
I'll
but
try.
Please, it's inappropriate. Thank you.
I'll do my best.
Thank you.
So just to be clear, was there anybody in the public lobby the day that I was trespassed? Were there any members of the public in there?
I don't recall noticing whether there was or was not on the video portion.
Thank you. If we could move on to the next one.
Whereas there are areas within city-owned, controlled, or leased buildings which are considered limited public forums as they either are limited areas open to the members of the public who are engaging in legitimate public business, or are primarily intended for the use of city employees in the conduct of their business, but may be utilized for convening public meetings and.
If I was in the lobby to submit an open records request in accordance with Chapter 119 of the Florida statutes, is that considered legitimate business?
Yes.
Are you familiar with the forum analysis?
I'm not familiar with that term, no, sir.
Did you present the forum analysis to the city commission when going through this ordinance forum analysis, by which I mean traditional public forum, limited public forum, non-public forum?
I did cover those terms.
Are you familiar with that?
I am.
Are you familiar with who applies the forum analysis?
Who applies it? I'm not sure I understand your question.
Is the forum analysis usually applied by city managers or by courts?
Are you asking if the city manager here has the authority to designate someplace as a limited public forum?
I'm asking if in the world of law, if that's permissible.
I'm going to object. The question is ambiguous, it's irrelevant, and it's called for legal
There's
conclusion.
two questions on the table. The second question, I'm sustaining the objection to. The rule of law, this one not, who makes the decision? I think the question, as I understand, I'm not sure I understand the question, is who may make those determinations? Is that your question, Mr. Gray? Whether it's a city manager, maybe designate public forums, limited public forums? Is that your question? I'm not sure I understand, so I don't know how the witness would, so help me out here.
My question is about his knowledge of that analysis, his knowledge of the forum analysis and how it's applied, and how it's not applied by city managers.
So he already testified he doesn't know what forum analysis is, so I don't know.
I think you revised his answer, though. You did, though, right? Once we got to
I'm not sure I understand your question, sir.
So the forum analysis, and then I got a little more granular. A traditional public forum, non-public forum, open public forum. You are familiar with those things, right?
I'm familiar with those terms, yes, sir.
Right. Is, in your opinion, strike that actually. Okay, we'll move past that. But just for clarity, no, we got that clear, actually. Never mind. We can move on to the next one, Chief.
Whereas the lobby of the police department is an example of such a limited public forum where uniformed or civilian employees interact with citizens who are there to engage in the legitimate public business of interacting with law enforcement for various purposes, including but not limited to reporting crimes, seeking or providing information, and assessing resources and.
Are you aware that I was alone in the lobby that day?
As I said earlier, I watched portions of the video. There was a portion when you were in the lobby. I do not recall whether there was anyone there or not with you.
Very good. Is anything that happens in that Do officers film everything that occurs in that public lobby?
Everything that occurs, I would have to say no.
Is there a CCTV camera in that lobby?
There is a camera in the lobby.
Is there audio?
There is not.
When officers come out, when Sergeant Gelm came out to speak with me that day, did he activate his body-worn camera?
Yes, he did.
If he came out, you gave an example of a young lady that was distressed. She was disturbed. If she came in and made her report, she filed a police report, let's say, would the contents of that police report be open to a public records request? After the investigation was concluded or after the case was closed, does that all become public record?
You're asking me a hypothetical that if a person comes in and files a report of a crime, once it's fully investigated, does it become public record?
Yes.
Anything that wouldn't be redacted in it, yes.
The public lobby, there, if there's too many people in the lobby or there's competing voices in the lobby, do you take people to an interview room or a secondary room for a little more privacy?
If the need arises, we do, yes.
So Longwood Police Department has the ability to take a conversation that they deem as private that is occurring in the public lobby, and they can take it to a more private area if they feel that privacy is at issue.
They can.
Yes. Thank you, Chief. Okay, we can move on to the next one.
Whereas the nature of the kinds of public business for which limited public forums are open to the public often involve the disclosure and discussion of private and sensitive information, making the privacy of citizens in such spaces of paramount importance. And
are you familiar with the case McDonough versus Fernandez-Rundle?
no,
Are you aware that in the state of Florida, somebody has surreptitiously recorded in the chief's office a conversation with the chief, and that went to the 11th Circuit and was found to be found lawful?
Objection. This is irrelevant and calls for legal testimony, and that mischaracterizes that case that I think he's referencing as a wiretapping case, not a case that involves an ordinance. That's before you, Your Honor.
I just asked a clarifying question. I didn't ask.
Whether it's relevant. So, Mr. Gray, I'm not going to keep you, but I'm just letting you know we're into this for almost 45 minutes, and I am going to give the city the same amount of time I'm giving you this morning. You probably have another 45 minutes before we're going to have a conversation if we're not going to conclude. I'd ask you to keep your comments relevant. I'm not certain that I don't believe that that's a relevant.
Well, it involves recording in private spaces, not public spaces.
So it's not relevant to this because this is I think it's been, everyone agrees this was a public space.
Right, but it involves recording the police. You can move on to the next one, Chief.
whereas, given the nature of the information being shared by the citizens in a limited public forum, coupled with citizens' obvious and reasonable...
We were past that one.
I apologize.
It's all right.
Whereas the City Commission finds that adoption of provisions of the city code prohibiting the unauthorized public access to restricted non-public areas and prohibiting video and or audio recording within an enclosed city-owned, controlled, or leased property not classified as a designated public forum is both reasonable and viewpoint neutral and is necessary for protecting the safety and welfare of the citizens of Longwood.
Just to be clear, I was never in an unauthorized restricted area, a non-public area, correct?
Objection asked and answered.
The answer was
Go ahead and answer it, sir. I'm going to overrule the objection.
You were not.
so I don't need to be redundant. Thank you. Could I admit the invoice? It's invoice PD 2025. Again,
Your exhibits.
it is. I can bring it up and show the chief if need be.
Give an opportunity to review it.
I don't think it's properly admitted. There hasn't been any foundation laid. I see that if this is the same invoice that was emailed earlier today, it's not dated. It was dated before this incident even occurred, like a month earlier, so I don't see how it's even relevant whatsoever to this proceeding.
What is the, I see an invoice.
So the invoice is
19/2025, correct? That's the records request invoice number PD 21025-582-IMB-1.
that's correct. Yeah, it was.
What is the,
It's a request for the body cam inside the lobby. I'm just pointing out that this isn't a neutral. There's nothing neutral about this. I'm barred from filming in the lobby, creating my own record. But if I want to obtain a record, I can pay the city for a record that I could create for free.
I'll leave it for that limited purpose. Just to state that you were charged for the video.
Again, not.
And you can argue from it later, because once it's in evidence, you don't have to restate it.
Thank
that's
you.
just a legal thing. I'm aware, and if you want to recite to it when you're giving me legal arguments at the end of your case,
Thank you.
or in writing, you can do that. But there's an invoice, unless the city claims it's not.
And just to be clear, I didn't pay the invoice. It's just an invoice.
It's an invoice. I didn't say that you paid it. I'm sorry. So that you were charged.
No worries. If you don't have it printed, I can give him a copy of it. I can give him my iPad. Can I take it to him?
He's got to establish the witness is familiar with the invoice.
Have you ever seen invoices from Longwood Police Department, Chief Dowda?
Have I ever seen invoices? Yes. I have not seen this one.
Does that look like a common invoice, or does that look like a legitimate invoice to you?
I've not seen this invoice before.
But is there any reason for you to believe that this is altered or fake in any way?
No, but I have not seen it before. Not typically part of the process for this to be
Sure.
distributed to someone, so I don't typically see these.
Sure. So I can come in to the Longwood Police, well, I guess I can call the Longwood Police Department right now since I can't go in, but I can obtain footage of my interaction with Sergeant Gelm in the public lobby. I just have to pay for it, right?
You can obtain it, and there is a cost to that video.
So the city is not allowing me to create my own record for free, but I can obtain a record from the city at a cost of, looks like, I don't know, it's $20 an hour, somewhere in that range.
I'm not sure I understand your question. Can you repeat it, please?
Sure. Is it your understanding that I can pay a fee and get a copy of my interaction in the public lobby, but I can't go into the public lobby and create that own record for myself for free.
That's correct.
Can you tell me how that's neutral?
Objection. I'm going to stop the testimony. He didn't say it was neutral. I don't think you can, he never said it was neutral. He just
The ordinance says it's neutral.
He didn't say it was neutral. You just asked him if he has to pay, if you have to pay versus, and he said yes. So, I mean, you have to establish a foundation for what you're
Sure. And I apologize. Did I not say, is that neutral, or what did I say?
I don't remember your exact words. He has to have some familiarity with what you have to cite him to some foundation that he knows with reference to what?
Sure.
What paragraph, in accordance with paragraph 3 of the ordinance, or whatever, reference, do a reference point.
Yeah, no, it was the one that he just read, that the public forum is both reasonable and viewpoint neutral. So I'm not trying to get him on a gotcha.
With reference to the language in the last
Yes.
whereas clause. Thank you.
Yes.
Your Honor,
I'm sorry.
If I may also just point out, Mr. Gray, you were provided a free copy of the body cam footage that you're alluding to, because I sent that to you through the Dropbox.
If that, you mean the other day with
Yes,
the
sir.
disclosures?
Yes, sir.
I never got a link, but
Okay.
I appreciate the city giving it to me for free.
All those exhibits, I received the same email, I believe, and they had your email address on it. I don't know if you clicked the link or not, but it was embedded in the email.
Okay, yeah, I didn't get it, but that only goes to the point of the most, I didn't even request the body cam from that event. This is a completely separate event, and I haven't received this for free. This is still an open invoice wanting me to pay for something that occurred in the public lobby.
I made the point. Let's move on. Thank you.
Are you aware that every circuit that has ruled on the right to record police has affirmed this right of the people?
I'm not aware of that. How are you referring to rulings where there is an ordinance restricting it in a police department's lobby?
I'm sorry, the answer was no.
Objection.
I don't understand your question.
I think that was the answer.
Oh.
Just asking you to clarify your question.
Every circuit in the United States of America that has ruled on the right to record police has affirmed that we have a right to record police. Are you aware of that?
I'm not aware of all the rulings of all the circuits in the United States of America, no, sir.
On the right to record police.
On the right to record police.
Right. Do you believe that observing and recording law enforcement personnel in public places is protected by the First Amendment?
Yes,
Just not in the public lobby?
not in a limited public forum where there is an ordinance restricting it, no, sir.
So you can record police, just not in your public lobby? Everywhere else in America, we're allowed to record the police, but your public lobby is special, and we can't record the police there. Am I to understand that correctly?
There is a reasonable expectation of privacy. in the
But you
lobby.
haven't cited any case saying that we have this reasonable right? It was just some training course that you and Dan went to? Am I to understand that correctly? You have no case law saying that this isn't a right, correct?
Sir,
Yes.
Mr. Gray, this witness has never been established to be a lawyer.
I didn't hear an objection.
I can ask you to keep your testimony relevant. I don't need an objection. I'm in charge of the proceeding, and I remember to the rules of evidence apply legally. Relevance is one of them. So I'm going to ask you, it's never been established that he has expert knowledge or any knowledge of extensive
He
knowledge.
just admitted
He's
to it.
enforcing, no, he said he's enforcing an ordinance.
He just admitted that observing law enforcement in public. Let me start over. He just admitted that observing and recording law enforcement personnel in public places is protected by the First Amendment. He said that.
I'm
And
objecting that. You're mischaracterizing.
We're already
what
past
he's-
that.
You're mischaracterizing what he said. He was very clear what he said.
He wasn't.
I can't testify right now for.
Neither can
His
you.
testimony, what he said is in the record, and what he said, and a particular interpretation of it is I can make mine, but I think that question's been asked and answered. Going down that hole of trying to ask him to tell you what the case law is, he's already well established that he's not an expert in the case law in the state of Florida on this issue.
Sure, not.
He knows what he knows and what he's testified to.
Sure. Chief Dowda, are you familiar with the case Brandsburg v. Hayes?
No, sir.
Are you aware of the case Atkins v. Limitacato?
No, sir.
Are you familiar with the case Houston versus the City of Houston versus Hill?
No, sir.
Are you familiar with Fields versus the City of Philadelphia?
No, sir.
Are you familiar with Frazier versus Evans?
No, sir.
How about Glick versus Kniff?
No, sir.
Mills versus Alabama?
No.
How about Snyder versus Phelps?
No.
So these are all cases that involve the police and the right to record.
Is that a question, Mr. Gray?
And you're not aware of any of them? Am I to understand that correctly?
I'm going to object. First of all, Mr. Gray, you've not established those cases mean anything like what you're claiming they mean. You haven't provided them to me or the magistrate, and I don't think this is a proper line of questioning for this witness.
Sustained.
Okay, I think Chief, do you remember when we met a few years ago?
I believe so. You're referring to the first time we met?
Yes, sir.
Yes.
Do you remember you and I having a recorded conversation in the public lobby?
Yes.
Did
You're referring to the police department's lobby?
Correct.
Yes.
Yeah, a number of years ago.
Yes.
I had asked you if you had received my email. Is that correct?
During that conversation?
Yes.
I don't remember you asking me that, no, sir.
You don't remember?
As you pointed out, it's been a number of years.
Sure. You don't remember having a long back and forth about how maybe the mail had been sent to your spam folder?
I don't remember having a conversation with you about it.
Are you aware that after that meeting, I made a public records request to the city?
Objection to relevance.
Sustained many years ago.
Goes to credibility, the chief's credibility.
He testified, he remembers the conversation. What do you,
I could bring up the video if we really wanted to press it.
what is the point you're trying to, credibility?
The point I'm trying to make is the chief said to me, "No, sir, I didn't receive your email that I sent from my normal email address. I didn't receive your email." And then I reached out to the city, and the city tech who handles the emails, who handles the text, said the email hit the city server and was in the chief's mailbox.
Think you can testify to that when you it's time for you to testify, it's appropriate, I think, you can ask the chief if he remembers it. But
Sure.
that's fine. You can ask a question. If he doesn't remember it, he doesn't remember. If he does, he does.
Do you remember lying about that, Chief?
Objection, yours.
I've never lied to you, sir.
You've never lied to me?
No, I have not.
So if you don't know the entire truth and make a statement, are you able to put yourself in that little box that you haven't lied?
Objection, the
I don't
question.
understand your
That's
question.
not an appropriate question. Sustain.
I think that's all the questions I have. What? I got one more for the chief. Chief, this was something that, this was the first question that I'd ever asked you. Well, not the first question. We went back and forth, me and Clint, and I imagine you brushed up on it before coming here today. It'd be kind of insane for you not to. If somebody came up to you and asked you a question and you didn't know the answer to it, would you make a good faith effort to find out the answer to that question?
Yes.
The First Amendment of the Constitution secures 5 fundamental freedoms to we the people. Any chance you can tell me what those 5 freedoms are?
Objection, relevance.
We're talking about freedom of speech. We're talking about freedom of press. That's what this whole thing is about.
I
Sustained.
understand that's your argument. I'm going to sustain the objection. He's not an expert in that.
He's literally signed an oath. He signed an oath to protect it. So did you. So did he. I'm all done.
Just with this witness, does he have any redirect, any cross-examination? You're going to say that for your case in chief, whatever you want to do.
The only question I have, Chief, is were you present in the police department lobby on September 4th for the incident for which we're here today on this appeal?
I was not.
Okay, that's all I have. Thank you.
You redirect on that one question?
No, no.
Sir, you may step down. It's time for you to call your next witness.
Callum.
I just want to point out that in about 30 minutes, you'll use a little more than half of the time this morning. I'm not going to restrict you, but I just wanted to let you know because I'm going to give the city approximately the same amount of time you need. How much time do you think you're going to need, Mr. Langley, to present your case this morning?
I think with plain,
I'm sorry.
we have a few videos that we're going to play, and they're probably going to take, I'd say we're probably going to need an hour and a half,
So
unfortunately.
that's going to be the whole, so we're going to have to stick pretty much, either that, or if there's evidence lengthy, you can introduce it, and I'm going to have to probably review some of these witnesses, some of these exhibits, case law and stuff before I order. I have 5 days in the ordinance, 5 business days to rule. Some of the evidence can be submitted. I want to make sure we make the most of our time.
I don't know if there's reason to show it, but I'm happy to stipulate that I was in the lobby filming. Actually, not filming. I wasn't in the lobby filming. I was in the lobby live streaming. But I mean, I'm not sure. I'm happy. Again, I'm happy to watch the videos, but I'm happy to stipulate that as well.
Are those videos that are in your evidence?
They are. If I may move to omit them at this time without the objection of the appellant, I'd like to do that. I can submit a flash drive copy. If you said you didn't receive them, I'll give you another copy of it.
If it's in a link,
It is.
I can download. I can do that. But
For the record, are they the videos that you just identify them so that the record picks up what they are? You
Yes.
provide an evidence list, but so that everyone knows clearly and
Right.
phrase where clearly would.
Okay, included in the link that was submitted with the appellee, City of Longwood's disclosure of exhibits filed earlier this week on the 22nd, is a copy of the ordinance 25-2266, which has already been jointly admitted and judicially noticed. Number 2, Sergeant Gillum's body cam footage from September 4th, 2025, documenting the interaction with Mr. Gray regarding the trespass warning. Number 3, Officer April's body cam footage from September 4, 2025, interaction with Mr. Gray regarding the trespass warning. Number 4, video posted by Mr. Gray of the September 4, 2025 interaction regarding the trespass warning on his YouTube page. Links provided. Also downloaded and provided the actual, file copy of it. Number 5 is the City of Longwood Police Department trespass warning report regarding the September 4, 2025 trespass warning of Mr. Gray. I do have other evidence to submit this morning in the form of documentation. Maybe we can go ahead and do it now without objection.
As long as Mr. Gray has a chance to review them and stipulates the visibility. If he doesn't, then we'll have to put them in individually during your case.
Well, I don't mind asking questions to get them in, but they're photographs of the door of the lobby?
No objection.
Okay. And then I have also a sworn statement by Marilyn Pardo of her interaction with what the evidence will show is Mr. Gray on the day of September
So again, you have
4th.
to show that to Mr. Gray. And then I'll need I don't.
Was this a supplement?
If you two need 5 minutes just to go through exhibits and look and come back to me with some stipulations, that's fine. We can take 5. Use the restroom if you need to do that, and would that be helpful?
I think 1 or 2 minutes is enough. Thank you.
Okay, well, all right, then I'm going to use the restroom. We'll take 5 minutes or 2 minutes when you're done exchanging exhibits, and I'm done with the restroom. We'll do that.
We're good to go. Chief, out of curiosity, I've been in an office, I don't know, several times. That the woman that you were referencing up there, that was not from one of my visits, was it? Because I actually try to go to great lengths to not get people on camera when they don't want to be. I'm sure you've purposefully ignored that in viewing any of my videos where I don't capture anybody's private information, but was that me? No, I'm talking about that specific.
I understand that you may try and do that, but
No, I'm addressing it because it's wrong. I'm addressing this issue because it's wrong. What you're doing to the people is wrong. But the question I'm specifically asking is about that woman. Whatever, it doesn't matter. So, again, was that woman, it matters to you, it doesn't matter to me. You violating your oath and doing that to the community, I'm sure you're proud of that, but I'm not. But anyway, the woman, was I the person in the lobby or not? Yes.
I wasn't in the lobby when that happened, so
You don't know.
I can't say.
Have you had an opportunity to confer and exchange exhibits?
Yes, no objections.
Okay, so tell me what the exhibits are that are stipulated to.
I have a picture of the front door of the police department lobby, which has the signage that clearly indicates video and audio recording in the police department lobby is prohibited except for law enforcement personnel in their law enforcement capacity. The other exhibit is I have a sworn statement by Marilyn Pardo concerning an incident occurring in the police department lobby on September 4th, 2025. Those are the two additional exhibits. I also have a hard copy of the trespass warning report if you want that.
I have a copy.
Okay.
The others I have not seen, so if you're going to submit them to evidence, we're going to have to put them in because they weren't provided.
And before I proceed, it might be helpful because I think Mr. Gray made a statement. I just want to be clear for the record. Mr. Gray, are you stipulating that you were in fact recording audio and video in the police department lobby on September 4th, 2025 as for which led to the trespass warning that you received?
I was live streaming, yes.
All right, I hate to do back and forth questions, but if I may, because this might short this process.
If I can just get Gellum out of the way and he wants to ask me questions, I'll go on the stand and let him ask me questions. I don't have questions to ask myself.
Why don't we call Sergeant Gum, because that's the appropriate way, that's where we're headed, and then if you, I know you're trying to shorten things.
I just have 2 questions for Gellum. Well, maybe a couple more. We'll see where it goes.
Okay, so I thought you were finished with your case in chief.
No, he said just that witness. He
Okay.
said he was going to call Sergeant Gum.
Yeah.
Okay,
Is that, do
thank
you have
you.
other witnesses this morning?
Just Sergeant Gellum.
Okay, all right. Sergeant Gum? When you get up to the podium, just state your name for the record, please. And your employment.
Hello, Sergeant Jesse Gellum.
And your position with the city of Longwood, please?
Patrol Sergeant for the City of Longwood Police Department.
Sergeant Gellum, I'm sorry, what was the date again?
Are you asking the day of the incident?
Yeah. 14th?
No, sir, it was September 4th.
Fourth.
Sergeant Gellum, on the date in question, September 4th, was there any member of the public in the public lobby when you came out to trespass me?
No.
No. Was I in the public lobby to conduct legitimate business?
No.
In your mind, is requesting public records legitimate business?
Not when you're intentionally violating the city ordinance.
So 2 things can't happen at the same time? Question?
2 things can happen at the same time.
Okay, because I was recording, the validity of my business is deemed, my business is unofficial at that point?
Correct.
Because I want to document my business for my records, it becomes unlawful and illegitimate.
Objection. This, again, it calls for legal conclusion and an interpretation of the ordinance that was being enforced in this case.
So I'm sorry.
I guess I would state the objection that the form of the question, there's many questions in that question. It's assuming some facts, not an evidence. But broken into smaller pieces, it might be admissible, but it's a lot of different things all in one. It might be helpful to the witness if you broke it down a little bit. I'll state the objection to the way the question was worded. You could rephrase it into smaller pieces because multiple questions are inappropriate.
Was I asking you for public records?
Yes.
And asking for public records is legitimate business.
If that's all you're doing, yes.
That's all you're doing. Could you expand on that?
You came in intentionally to record in violation of the city ordinance, which you were already aware of.
We'll have to watch the video, but isn't it true that I said I was coming in to request public records?
Yes.
Okay. So this looks like, have you seen this before?
Yes.
This is the ordinance right here. Video and audio recording in the police department lobby is prohibited except law enforcement personnel in their law enforcement capacity. And to your understanding, that's basically what the ordinance is, right?
That's what it is referencing, yes.
Right. If there was an ordinance that said no blacks, would you enforce that ordinance as well?
Objection. This is out of the balance. It doesn't establish.
Abstain.
Sergeant Gelm, do you blindly enforce the ordinances?
Objection. That is an improper question.
What's improper about it?
If you're going to ask him to give a hypothetical that how he does things, you have to have a foundation. Like it has to bear some kind of. I understand you're asking him. The word of blindly is conclusory.
Okay. So we've got this ordinance here. It violates the Constitution, but you enforce it anyway, right?
Objection form of question assumes.
Abstain.
If the objection was in the form of a question, I did ask a question.
The question you asked was making allegations not in evidence or supported by any facts or law.
He objected to the form,
Form
not
of
the
the question.
substance.
You assume things have not been established in your question. So if you want to ask him if he's going to enforce that ordinance.
Very good. Would you, I'm sorry, Your Honor. Sergeant Gelm, would you enforce any ordinance no matter what it said?
No.
What is the line of delineation for you?
What I believe would be legal or not, or
Are you familiar with the right to record?
in general, yes.
So in general, we have the right to record police.
In general, yes.
So in all, how many years have you been an officer?
Almost
20. So in 20 years, have you ever seen an ordinance strip away fundamental rights?
I don't believe it's stripping away any fundamental rights, but I have not seen any other police departments or ordinances. I don't really pay attention to what they are in the county.
And you, the day of this ordinance, you had a conversation with me and Matt. You said you had read this ordinance and that you were very familiar with it. Is that correct?
Somewhat familiar with it.
Somewhat familiar with it?
Yes.
Did you? I think that's all I've got, actually. Yeah, that's all I've got.
Does the city have any cross-examination of this witness?
I really have more of a direct, but do you want me to go ahead and do it now just to get it out of the way?
Well, if we're going to have that, it really doesn't matter to me. Is this your last witness, or are you going to test for anyone else?
If he, I mean, I'm open to him questioning me. I don't really
Since
care.
This is already here, and he could go back to his duties when we're done with him. If you're all right with that,
That sounds
Mr.
good.
Ray, why don't we go ahead and take care of the direct examination, Sergeant? So when he's done, will he be free to return to his duties today when he's done testifying?
I don't think I'll have further questions for him
All right.
outside of what he's about to say.
Good morning, sir. This might sound a little redundant. I'm trying not to be, but I think we need just to get on the record a few things. Were you present and working at the Longwood Police Department building located at 235 West Church, Longwood on September 4th, 2025?
Yes.
And what is your rank with the Longwood Police Department?
Sergeant.
How long have you been a member of the police department?
Almost 20 years.
And I believe you already said you are generally familiar with Ordinance 25-2266 prohibiting recording of video and audio in the PD lobby, correct?
Yes.
Are you aware that ordinance also provides other things other than that one prohibition?
Yes.
Other than the existence of the ordinance itself, how does the police department advise members of the public of the prohibition of video and audio recording inside the PD lobby?
It's posted on the front doors as you walk in.
And I believe there, you probably saw the picture that's been in evidence already. Is this picture accurate representation of the sign posted on the front door of the lobby?
Yes.
And what is the consequence of a person violating the prohibition of recording video and or audio within the lobby of the police department?
Can result in trespass and a charge of city ordinance violation.
And can you generally tell me what is the protocol for issuing someone a trespass warning for violating ordinance 25-2266?
In general, we would notify the person. Video, audio recording is not allowed in the police department lobby. If they weren't already aware, then if they wanted to stop recording and step outside, that would be fine. If they refuse to stop recording, then they could be trespassed and asked to leave the lobby.
So a person that's observed to be video or audio recording is giving more than one opportunity to cease that activity before they're asked to leave the lobby. Is that correct?
Yes.
And do you specifically recall the incident occurring on September 4th, 2025 in the police department lobby involving Mr. Gray?
Yes.
Mr. Gray is present with us today, correct? This gentleman over here?
Yes.
And how did you come about entering the police department lobby to correspond with Mr. Gray on September 4th?
Through the side door, I guess you could say, leading from the interior restricted area of the police department into the lobby.
And what prompted you to enter the lobby to interact with Mr. Gray?
I was notified there was a gentleman in the lobby who had notified Ms. Pardo that he was in the lobby and filming.
So it was Ms. Pardo that asked you to, or informed you that Mr. Gray was present filming in the lobby?
I believe she asked the deputy chief, who then told me, but I was informed after that incident.
But specifically, Ms. Pardo indicated to Deputy Chief that Mr. Gray told her that he was filming in the lobby.
I believe so, yes.
When you entered the lobby to interact with Mr. Gray, was there another officer with you?
Yes.
And which officer was that?
Officer April.
Okay. And as you entered the lobby or before, did you and Officer April activate your body cam?
Yes.
Okay. And there's already been admitted in evidence without objection to video files of body cam footage of Sergeant Gillum and Officer April. So I don't think I need to lay any further foundations in the evidence already. When you entered the police department lobby on September 4th, did you observe Mr. Gray recording in violation of Ordinance 2526?
Yes.
And what actions or statements did Mr. Gray take or make to give you the observation Mr. Gray was recording in violation of the ordinance?
He was holding a, looked like a cell phone recording device on some sort of mounting with a handle on it that he was holding, following me around with it. And also indicated that he was doing that for his protection.
So when he said he was doing, aiming his camera at you for his protection, how did you take that?
That he was recording.
Unless we're going to reference the videos, can we take down the photos that we're seeing here?
Well-
We're not, unless we're testifying from them. If we are, that's fine.
Yeah, I think I might,
If we are, okay, then put up the one we're going to use, because if there's no testimony about it, I want it there as a visual.
I think it might be helpful for everybody to view the body cam footage for a little bit as Sergeant Gelb's entering. If we can play the video body cam footage of Sergeant Gelb for a little bit. I don't want to.
Objection. I've already stipulated that I was in there. We're just wasting time.
Is there a, do you know the number, because I could look at it myself later even, if you just want to tell me from this minute to this minute, do you know the time or how long? If it's a
We're
minute
in
or
there
two?
for less than
Well,
3 minutes.
I just want to play the part what we're testifying to right now, where he's holding up his camera, aiming, just to collaborate the testimony.
Filming today?
Okay, I'll allow it. Short.
Filming is not allowed in the building, it's in the lobby, okay? It's properly posted out there, we've told you before. You're acting like you're filming. Video or audio recording, yeah, not filming. Okay, are you video or audio recording? Okay, or you're making it seem like you are. Okay. You're being trespassed from the lobby if you do not leave. So I can't make my public records request? If you put that down, you're giving me the impression that you're audio or video recording by holding it up. Okay.
So can I make a public records request?
If you put that down,
I can't put it down, it's for my safety.
okay, you're gonna be trespassed in the lobby. If you refuse to leave,
I'm gonna leave right now, but I just wanna make sure, can I submit my public records request?
you can make it by phone, or I can step outside and help you.
Please,
Okay.
I just wanna be clear, if I don't leave the lobby, I'm going to be arrested.
No, you're gonna be trespassed.
Trespass.
Yes.
Aren't I being trespassed right now?
Yes, you're gonna be trespassed or step outside the
But
lobby.
if I don't leave the lobby, I'll be arrested for trespassing.
I'm the one, yes,
Very, very good.
yes. Thank you.
All right, we could stop at that point, and Your Honor can review the rest of it, but I just wanted to show the most significant portion. Sergeant, is it clear to Mr. Gray lied to you during your investigation of him as to whether he was recording in the lobby in that incident that we just saw?
Yes,
In that footage, we just heard Mr. Gray indicate that he was not, in fact, recording in the lobby, correct?
yes,
Have you, before September 4th, had any interactions with Mr. Gray?
yes,
Any of those interactions, when Mr. Gray indicate to you that he had, in fact, prior knowledge that it was a violation of the ordinance to record audio, video in the police department lobby?
yes.
And can you expand on that testimony? Why do you think Mr. Gray was?
Objection goes to my thoughts.
I'm asking for personal knowledge as the sergeant's interaction with Mr. Gray.
Ask the question again, please.
Yeah, just asking to expand on the testimony. He just indicated that he's aware that Mr. Gray, from Mr. Gray's prior interactions with the sergeant, that Mr. Gray was aware that the ordinance existed and it was a violation to record inside the police department lobby.
So I guess your question is he aware or how is he aware?
How is he aware? Because you just said he was aware.
You can answer the question, I'll overrule the objection.
Okay. So I've had previous contact with him at the police department, where he's been notified of the city ordinance, and we briefly discussed it. I've also watched a live feed video previous to that, where he came to the commission in this very room and explained to them he was aware of it. Basically, obviously he doesn't like it, and that he was going to be getting himself trespassed out of the police department.
Okay, during that incident of September 4th, did you in fact issue Mr. Gray a trespass warning for violating ordinance in the sign posted on the door?
Yes.
And did you verbally issue the trespass warning?
Yes.
And then did you later also fill out a trespass warning report and file it within the PD system?
Yes.
Okay. And Your Honor, there hasn't been an objection. It's already been
I
admitted.
think it was stipulated into evidence.
Right. So
Is
that,
that correct, Mr. Gray?
Yeah.
And in the trespass warning report, sir, there's a statement that after the incident, it was later determined that Mr. Gray was in fact recording because his recording was posted on YouTube. Is that correct?
Yes.
So did the police department, yourself or someone else in the police department, download the YouTube video and watch it of the incident that Mr. Gray, that interaction with Mr. Gray that he posted on his YouTube page?
Objection, relevance. We're talking about a separate incident, right?
No, sir. I'm talking about the September 4th incident.
Sorry, never mind.
I did watch a little bit of the live feed that was going on, and then it was recorded as well.
Okay, so
And posted to the evidence.
So the live feed that you watched on YouTube confirmed everything that you observed. Mr. Gray was in fact violating the ordinance that prohibited video and audio recording in the police department lobby, correct?
Yes.
So during that incident, was Mr. Gray, well, outside the PD lobby with another person?
Objection, relevance.
Why do you think it's not relevant?
Why does it matter if I was out there with another person? We've already stipulated, I'm outside of the lobby. It doesn't matter it doesn't matter if the president was there. Was I in the lobby filming? We've already established that I was. I've already admitted that I was. Why are we talking about other people that have nothing to do with this, who aren't in the room to say anything about what he's saying?
Yeah, the only reason I bring it up, Your Honor, is because the person who was there with was the person trespass warned, and so it just goes to Mr. Gray's prior knowledge of this ordinance and the fact he was there intentionally violating it and wasn't there on legitimate business.
Two things can be true at the same time.
That's correct. I'm going to overrule the objection for that limited purpose to establish the knowledge that you were aware of the ordinance and that this could constitute an act of trespass, but for that limited purpose only.
Let me withdraw the question and ask it a different way, if I may. Sergeant Gray, or I'm sorry, Gillum, was Mr. Matthew Armstrong present
Objection, relevance.
on September 4th outside of the police department lobby when Mr. Gray was being asked to leave the lobby?
I'm going to overrule the objection. Go ahead and answer.
Mr. Armstrong was outside.
Ian, is Mr. Armstrong?
Objection, relevance.
Please let me finish my question.
Then finish the, so I couldn't hear the one part you said if it's relevant or not.
Is Mr. Matthew Armstrong an individual that was also recently given a trespass warning for filming or video, audio recording in the police department lobby?
The objection's overruled. You can answer the question because now we finished this question.
Yes.
And are you aware whether or not Mr. Armstrong and Mr. Gray correspond and interact together concerning
Objection, relevance.
their mutual desire to film in the police department lobby and post things on YouTube?
Objection's overruled.
Yes, they do that.
Just to recap, what is the totality of why you issued a trespass warning?
Objection, asked and answered.
I'm asking them to give a synopsis.
Do we need a synopsis?
Yeah, just
It's asked
to
and answered.
Just to recap, what is the totality of the reason you issued a trespass warning to Mr. Gray on September 4th, 2025?
We're not going to rule on the objection?
Thinking for a minute.
Thank you, Your Honor.
I get a minute to think. I'll allow one question, but we don't really need to recap the whole thing again. I will overrule the objection on a limited basis, but if that's the point you want to make, fine, ask the question, but I think that's been established. I've got the testimony, I understand what was said.
Thank you, Your Honor.
Go ahead and answer it.
The totality of the circumstances was Mr. Gray had previously been notified of the city ordinance and that he could not film or record video or audio inside the police department lobby. Used terminology before indicating that he's filming for his protection. He told the city commission that he was going to be getting trespassed from the police department lobby. He told Ms. Pardo, then provided a sworn statement for me, and I believe I saw that on the video myself, that he told her he was filming made it clear when he came in. He also was holding up looked like a cell phone, a recording device, and followed me around the police department inside the lobby with it, and then continued outside the police department.
Thank you. And with respect to making public records requests, is it possible for a member of the public to obtain public records through the city's public portal on its website?
Yes.
Is it possible for a member of the public to obtain public records by calling the custodian of records via telephone?
Yes.
On that day, September 4th, 2025, when you exited the lobby with Mr. Gray, escorted him out, did you proceed to accommodate his public records request outside the lobby, outside the building?
Yes.
Just curious, I don't know the answer to this, I shouldn't ask it, but did Mr. Gray ever, did he really want those records? Did he proceed to ask for them?
Objection.
Sustained. Don't answer the question.
Okay. All right, that's all the questions I have. Thank you.
Do you have any redirect of the witness, anything that?
I do, yes.
Only limited to whenever Mr. Langley has
Yeah,
questions.
yeah.
Follow-up.
Do you wear your body cam for officer safety? Is that one of the reasons?
One of the reasons.
Is it unreasonable to assume that if a member of the public wants to record their interactions, it might be because they want to do it for their safety?
Could be.
I know that do you have a YouTube channel?
I'm sorry?
Do you have a YouTube channel?
I do not.
No. Mr. Langley mentioned that I lied to you. What lie did I tell?
You told me you were not filming or recording in the police department lobby.
Did I tell you I wasn't filming or recording, or did I tell you that I wasn't filming?
You told me you weren't filming or recording.
Really? Did I? Can we bring that back up? Because can we perjure the witness?
You want to play it? It'll show that his testimony is
You can-
accurate.
The record will say what it'll say. I mean, I don't know if the clerk has the ability to go back and replay it right here and now. This is
Of course she
being
does.
recorded, so I think it's clear the point you're trying to make. I don't think you need.
Yeah, I was live streaming. I didn't tell a lie to the officer. Yeah, there's a nuance, right? And I exploited the nuance, and you want to call me a liar for that. Okay, cool story.
You want to play the video or not?
Nah, forget about it.
Okay.
I
You're-
think I understand the point you're trying to make.
Right.
We're not here to call you a liar or not. I understand.
Well, somebody is.
I understand that there was an impression made that was, whether it was recording, live stream, or whatever, I understand that there was everyone agrees that there was some sort of pictorial video of that was posted to YouTube, so I think.
All right, very good. I don't have anything else for Sergeant Gill.
Sergeant Galvin, anything else, Mr. Langley?
No, thank you. Appreciate your
Sergeant
time.
Galvin, you may return to your rest of your day,
Thank you.
or stay, it's a public hearing. Next witness, Mr. Gray.
No, I'm all set.
Concluded your case?
I still have a closing, right?
Yes, you have time to make a conclusion. That's after the city finishes its case, and then there would be closing. So, Mr. Langley, you could make an open, well, you've already made your open. You can call your witnesses, and when we're done with cross-examination of witnesses, we'll proceed to closings.
Your Honor, thank you. I had two witnesses, and Mr. Galvin, or Sergeant Galvin was already called, and I already did essentially my direct. I had a second witness. I don't think it's necessary based on stipulation and Mr. Gray, but
Sorry to jump in. If Mr. Langley has questions for me, I'm happy to take the stand and be questioned.
yes, I'd like that. I have a few questions.
I have a question. There's these two exhibits that were handed to me by the city. These are originals, so I'm not going to hang on to them because I'm not a custodian of public records.
I think they might be
I'm gonna
color
want
copies.
of these.
I think they just might be color copies because I have a color one as
I
well.
have these both color. Are these copies or these originals?
These are copies.
Okay, so it's pretty good color. Okay, I just want to make sure I can retain them for my file because they are, the one in blue I wasn't sure was an original. Okay, thank you. I'm glad to know it's a color copy. Thank you.
All right, so I'd like to call Mr. Gray to the witness stand.
When you get to the witness stand, Mr. Gregg, please just make sure to identify yourself.
Joshua Gray.
Good morning. Before September 4th, 2025, when you entered the police department lobby, were you aware that the city of Longwood had an ordinance that prohibited recording audio or video within the police department lobby?
Yes, I was aware of the ordinance.
Were you aware specifically that it was prohibited to video, audio record within the police department lobby?
I was aware that that's what it said.
Did you observe the sign on the front door of the police department lobby that I'm holding up?
I saw those unconstitutional signs, yes.
Do you think there's a difference between live streaming on YouTube and recording?
Yes.
Did you take the live stream video and edit it and upload it to YouTube?
I believe I did.
Okay, so wouldn't you agree the live stream content was in fact recorded in a digital format that allowed you to edit and post it on YouTube?
YouTube captured, yes, YouTube captured that, and I edited YouTube's video.
Okay, and that video had both visual and audio components, correct?
It did, yes.
So you would not agree that the video that we can hear and see is not a recording of the incident that occurred?
When I would not agree. When I record, like, for example, I'm recording over there on 2 cameras, and when I hit the stop button, I will have a record. I will have a recording of that on my phone. It's a copy of it that is housed on my phone. The live streaming is not, I do not get a copy on my phone at the live streaming. That's completely different.
So we stipulated to some exhibits, one of which was the YouTube video that you had posted. And
I'm not sure if I'm actually not sure if you admit the live stream or the one after. So I'm not sure.
The one after, the one that you edited.
The edited one.
Yes, sir.
Okay.
Anyway, if I or the police department was able to download a file of the incident that you posted on YouTube or YouTube posted, how is that digital format not a recording?
I can't speak to technical nuances of YouTube. I just know that I live streamed and I'm recording right now. So I have a copy when I'm done, and when I live stream, I don't. It's on the internet.
So we saw portions of a body cam footage of Sergeant Gelm this morning. Is that footage a recording of the incident? It is. So you think there's a distinction between body cam footage being a recording and what you had posted on YouTube not being recorded?
I think it's obvious that those two things are different, yes.
Okay, may I ask a question, just to help me?
Sure.
So, because I'm not super techie, so the live stream is your testimony. The live stream is not a recording because you don't retain a copy of it.
I'm not saying that live streaming, that YouTube doesn't save their own copy of the recording. I'm just saying that it's not a recording per se.
Okay.
That's just.
Thank you for clarifying.
You're welcome, Your Honor.
How were you able to edit the content of the video if you didn't have a recording of that content?
I downloaded it after the fact from YouTube.
Okay. So that would be a recording of the incident that you caused to occur?
I'm sorry, I don't know.
You caused the video audio recording to be on YouTube, which you later were able to download and edit, correct?
I'm the person that was holding the phone during the live stream, yes.
And during that live stream, you actually denied that you were recording to the sergeant, correct?
That's correct, yes, because I wasn't.
Sorry, just give me a moment. We've covered a lot of ground today. And I think the facts establish this, but just to be clear, you were continuing to record audio and video after Sergeant Gelm came out to the lobby and informed you that you were not allowed to record in that area, correct?
You're saying something different than the facts that we just discussed. We were talking about live streaming, you just mentioned recording again
Okay.
for some reason.
Right. So I don't see your distinction you're drawing. So
Because you're a lawyer, you're not a
Okay,
YouTuber.
let's get this to question and answer. I understand the point.
I'm still waiting for a
No,
question.
I do understand the point you're trying to make, so.
Thank you, Your Honor.
were you continuing to live stream on YouTube the incident with in the police department lobby on September 4th, 2025, after Sergeant Gelm informed you that you were not allowed to record inside the police department lobby?
Repeat that one more time.
You continued to record or live stream.
For live stream. I did not cease the activity between the time that Sergeant Gelm came out and you saw me leave the lobby. So Sergeant Gelm came out and warned me I could not record in the lobby, and I exited the lobby.
You continued to record
I
after.
did not shut off any devices during that time, no. Just like if I asked Sergeant Gelm to turn off his body cam, he would not do that. It's his job.
And did you receive a written trespass warning from Sergeant Gelm or from the police department after the incident occurred on September 4th?
Not that day, like I requested.
But you did receive it ultimately?
I think you actually emailed it to me, but no, I never received anything in the mail. I never received proper service.
Have you been found guilty by the Special Magistrate Emery Kidd, Federal Court Middle District, of unlawfully videoing, recording, or failing to comply with official signs or directives while at a Social Security office?
I'm sure you know how due process works. That's on appeal.
Okay. But the answer is yes?
It doesn't really matter. It's on appeal. Due process hasn't been established. It's on appeal.
Okay. That's all I have. Thank you.
Do you have any rebuttal testimony to what you're asked for cross-examination?
I don't believe so. I don't know how to ask
I know.
myself questions. You know what I mean?
You're doing remarkably well for a non-trained lawyer. You're handling it pretty well, so kudos to you. But if you have something, if you have any testimony responsive to what Attorney Langley.
I don't think so. If I have a closing, I do have some closing remarks. I think that you understand the nuance, whether or not you recognize it, it's another issue, but.
No, I was very clear, so, but I want to make sure you're given that opportunity to
Absolutely.
additional testimony. Okay, you can return to your
Thank you.
seat. Do either of you have any other witnesses, rebuttal witnesses, any other evidence either one of you wishes to submit, and then we'll proceed to closings. If there are, and this is a question, so I'm fine with verbal closings. I'd like to hear everyone orally. I don't know if there are additional materials either one of you wants to submit, whether there's case law, so that I can consider those things. It's really up to your pleasure in your closing if there's additional materials you want me to consider, copies of cases.
I have something written out verbally. I'm happy to print that out and provide a copy to both you and Mr. Langley. It does have all of the relevant case law to what we're talking about here today. So I definitely do want to make sure that I get that.
You have my
I do,
email.
yep.
You can email it to both of us at the
Yep.
same time, just like I would email both of you at the same time, because that would be helpful.
Yeah.
But I will conclude my hearing, so I have 5 business days after the hearing to rule, so I want to make sure I have everything I have from both of you. So when do you think I would have?
I'll try to
all
get
that?
it to you today, tomorrow at the very latest,
Okay,
but I will try to get it
all
today
right,
because
so
I should have
if
had it prior.
I understand. So any materials that are provided to me, so can everyone safely say they'll be to me by Monday, close of business? Is that enough time for both of you? If there's anything additional, case law, you need additional time. You're still going to closing today, but if you have, I want to have ample time because I'm going to take that. I won't close the hearing until I have the materials, right?
It's adequate. However, I would ask if there's information that I haven't gotten before, wouldn't mind to have an opportunity to have a little more time after I actually receive it to be able
I'll
to.
tell you what. So if I will forward either one of you sends me. I don't want to have a back and forth. So it's like really, if you send materials and that generates your request for additional materials, it's 5 days after you receive any materials from Mr. Gray. If you want to supplement that, sufficient? How much time would you need after that?
I just want to clarify, what we're talking about additional materials would only be like case law?
Case law, I think that's.
Okay.
Yeah, I mean, basically, I'm going to make a statement right now, and it houses some case law within it. I just want to be able to deliver that case law, so you're not, what's he talking about, and having to go look for it yourself. You know what I mean?
Yeah, I think, okay, I think submittals should be limited to case law or legal argument, not additional
No, I don't
evidence.
mean any additional, I mean, case law, legal arguments, anything, you've omitted, or you want to mention a case citations. If you could submit them by Monday at 5, Mr. Gray, and if the city, if you want, how much time would you need after that to submit anything?
Yeah, by Friday.
As long as the Longwood PD doesn't arrest me on my way out today.
You can record these hearings as a public, so you're good. By Friday the 31st, I will have, if you submit by Monday, submit by the 31st, and I will have 5 business days to rule. So it would be the first Friday in November, which I don't remember the date, but it's November 5th, am I right?
The 7th.
7th, okay. So I have 5 days from when I receive all the material, so I'm gonna leave that open.
Thank you, Your Honor.
Everything will close on the 31st, and you will hear from me by the 7th in writing. Okay, but I do want closing arguments. Mr. Gray, I'll let you go first and present your closing argument.
Thank you, Your Honor.
Followed by the city.
Thank you, Your Honor. Every circuit that has ruled on the right to record police has affirmed this right of the people. Observing and recording law enforcement personnel in public places is protected by the First Amendment. Not only is the right to observe and record law enforcement activities and personnel in public places an established First Amendment right, but it is the right essential to protect the citizen press, which plays an ever increasingly important role in the dissemination of information. Indeed, the right to record police activity is important not only as a form of expression, but also as a practical check on police power. Recordings of police misconduct have played a vital role in the national conversation about criminal justice for decades. Crocker versus Beatty out of the 11th Circuit. In Brandsburg v. Hayes, the Supreme Court noted that without some protection for seeking out the news, freedom of press could be eviscerated. This was 1972. Professor Crimer explains, imagine image capture can document activities that are proper subjects of public deliberation, which the protagonists would prefer to keep hidden and deniable. Seth Kramer, pervasive image capture in the First Amendment, memory, discourse, and the right to record. Police regularly operate on public streets, sidewalks, which are areas that have historically been open to the public for speech activities, McCollum versus Coakley. Moreover, the conduct of the police as government officials as a matter of public concern, the speech regarding matters of public concern is, as the court has repeatedly reiterated, including in Snyder v. Phelps, 2011, at the heart of the First Amendment. Such a loss of First Amendment freedoms for even minimal periods of time unquestionably constitute irreparable injury. That's Elrod v. Burns. It is no surprise that several federal courts of appeals have found the constitutional right to record law enforcement personnel when they conduct operations in public, like public lobbies. See Iziera v. Yahaya out of the 10th Circuit, 2022, listening and summarizing cases finding a First Amendment right to film the police in public from the 1st, 3rd, 5th, 7th, 9th, and 11th Circuits, and holding the right to be clearly established beyond debate. The 9th Circuit, for example, has held that an individual's First Amendment rights were clearly established at the time of his arrest when photographing police actions, Atkins v. Limitaco. The First Circuit framed the question directly by asking, is there a constitutionally protected right to videotape police carrying out their duties in public, Glick v. Kniff? The answer to that question, the court held that basic First Amendment principles, along with case law from this and other circuits, answer that question unambiguously in the affirmative. Gathering information about government officials in the form that can be readily disseminated to others serves as a cardinal First Amendment interest in protecting and promoting the free discussion of governmental affairs. Quoting Mills versus Alabama, in so ruling, the First Circuit applied the following logic. If police officers must accept a significant amount of verbal criticism and challenge directed at them, then they must be expected to exercise similar restraint when they are merely the subject of videotaping that memorializing without impairing their work in public spaces. I was never accused of creating disturbance. Silently recording is non-expressive activity without impairing their work in public spaces. Quoting from Houston versus Hill, likewise, the 11th Circuit held that civilians have a First Amendment right to record the police because First Amendment protects the right to gather information about what public officials do on public property. Smith v. Cumming, that's the 11th Circuit, 2000. Perhaps more telling in upholding the right to record law enforcement personnel, the 7th Circuit described an extreme position, an extraordinary argument, the contention that the state attorney that openly recorded what police officers say while performing the duties is traditional public fora, streets, sidewalks, plazas, parks, public lobbies, is wholly unprotected by the First Amendment. And Civil Liberties Union of Illinois versus Alvarez. The 7th Circuit went on to hold that audio and visual recording are media of expression commonly used for the preservation and dissemination of information and ideas and are thus included within the free speech and free press guarantee of the First and 14th Amendments. Laws that restrict the use of expressive media that are obvious efforts on speech and press rights. The Supreme Court has voiced particular concern with laws that foreclose an entire medium of expression. The act of filmmaking, the act of audio and audio-visual recording is necessarily included within the First Amendment's guarantee of speech and press rights as a corollary of the right to disseminate the resulting recording. The right to publish or broadcast in audio or audiovisual recording would be insecure or largely ineffective if the antecedent act of making the recording is wholly unprotected. This is from Azara. The First Amendment taking at wholly unprotected. By way of a simple analogy, banning photography or note-taking at a public event would raise serious First Amendment concerns of law that would obviously affect the right to publish and resulting photograph or disseminate a report derived from the notes. The same is true of a ban on audio or audiovisual recording. More recently, the Third Circuit upheld the right of individuals to photograph or videotape law enforcement personnel in public. See Fields. In sum, the First Amendment right of access to information, the public has commensurate right to record, photograph, film, or audio record police officers conducting official police activity in public areas. Likewise, the 10th Circuit has found that filming police was an clearly established First Amendment activity and therefore denied qualified immunity to an officer who obstructed a civilian's recording. These cases show that the First Amendment right to observe and record law enforcement personnel in public is now well established. See Fields. Every Circuit Court of Appeals to address the issue has held that there is a First Amendment right to record police activity in public. As the 7th, 8th, 10th Circuits have explained, the antecedent acts of recording, like observation, must necessarily be protected as well. Alvarez, the 7th Circuit, Chestnut v. Wallace, 8th Circuit. If the Constitution protects one who records police activity, then it surely protects one who merely observes it. Izahari, if that's out of the 10th Circuit. If the creation of speech did not warrant protection under the First Amendment, the government could bypass the Constitution by simply proceeding upstream and damning the source of the speech. Filming the police acts as a watchdog of the government activity, furthers the debate on matters of public concern is a Hari. Thus, it is likely that the opposition to observation and recording of the police activities stems from the fact that many would prefer to be in a position to shape perceptions of their actions without competing digital records. Police officers often view private digital image capture as a challenge to their authority. This, rather than purported safety concerns associated with being recorded, has resulted in a rich set of cases in which the police have sought to prosecute critics or potential critics who captured their images. In these cases, police officers and their other officials have enlisted both existing statutes and creative prosecutorial discretion in the struggle to constrain inconvenient image capture. Until recently, if not continued, police officers have invoked the wiretap statute against those who antagonize them by recording. Indeed, the typical police officer, plaintiff, or complainant in the image capture cases canvassed is not concerned with avoiding observation or preserving seclusion. We are interested rather in assuring that the evidence of dubious or potential embarrassing actions is not credibly conveyed by the observer to a wider audience by transmission of the captured image. There are few cases on record of police officers arresting tourists who capture videos of polite official responses to inquiries for directions. Prohibitions on the image capture are deployed to suppress inconvenient truths. Such conduct cannot be countenanced in a society in which the freedom of individuals verbally to oppose and challenge police action without thereby risking arrest is one of the principal characteristics by which we distinguish a free nation from a police state. That's from Houston v. Hill. The First Amendment demands some sacrifice of police efficiency to the forces of private opposition. A police officer is not a law unto himself. He cannot give an order that has no colorable legal basis and then arrest the person who defies it. So here it is, because my actions were peaceful, not performed in the derogation of any law, and done in the exercise of my First Amendment rights, Sergeant Gelm lacked the authority to stop Mr. Gray from recording. And I'd just like to make one final point on a case that I thought I had in front of me, and that's Garland v. Price, talking about the forum analysis, the ordinance hypothesis that public lobbies are non-public forum. In Price v. Garland, the United States argues that the syllogism proceeds from a flawed major premise, not because every activity the First Amendment protects as speech benefits from the strict speech protective rules of a public forum. Because the filmmaker does not seek to communicate with others at the location from which he or she films, the filmmaker does not use the location as a forum. Therefore, the United States argues that the district court's forum analysis was misplaced. We think the government is correct. Based upon the historical underpinnings of the forum analysis, the evolution of the analytical framework, and the cases in which the Supreme Court has applied it, we are convinced that it would be a category error to apply the speech protective rules of a public forum to a regulation of an activity that involves merely a non-communicative step in the production of speech. Although that activity warrants solicitude under the First Amendment, that solicitude does not come from the speech protective rules of the public forum. In reaching this conclusion, we are buoyed by the Supreme Court's warning against extending public forum doctrine in a mechanical way to the context that meaningfully differ from those in which the doctrine was traditionally applied. And that's from Arkansas Education Television versus Forbes.
Is the site for Garland v. Price going to be in your materials you're providing?
It will be, yeah.
Okay, so
I have further citation. I just didn't read
No, I meant the case so I can read the case myself.
Absolutely.
I just want to make sure it's in the materials.
Absolutely. And that is, I was in a public space They like to hammer the time, place, and manner. The public lobby was open. Time, place, in a manner that's open to the public lobby, in a manner that doesn't disturb anybody's work. Well, there wasn't anybody in there to disturb, so it seems outrageous that I could be accused of creating a disturbance. Thank you, Your Honor.
Appreciate that. Mr. Langley?
Thank you. I think the evidence is clear that Mr. Gray was in fact recording audio and video in the lobby on September 4th. I think it's clearly violated the ordinance. As I understand Mr. Gray's argument, he's really not contesting that he violated the ordinance or that Sergeant Gillum issued the trespass warning correctly under the protocol. I think he's just claiming the ordinance is unconstitutional. He's entitled to his opinion, but his opinion is incorrect. The case law that he cited is not applicable. The case law he's citing, even though I haven't seen it, but I can tell from what I haven't seen it because he hasn't brought it today, and I will read it. But everything he referenced, he's talking about public spaces, and there is a distinction between public parks, sidewalks, public spaces, and limited public forums. The lobby is not a public space in the public forum analysis of those cases that he's referencing. I will submit to you a very specific case, and Mr. Gray referenced the Punta Gorda Code for a reason, and that's because there's a Middle District of Florida case called Sheets versus City of Punta Gorda, where the court, and that's the Middle District, which is Middle District also is governs this area, state, very specifically analyzed the code that Punta Gorda passed that actually prohibited recording inside City Hall, even in the open areas to the public, without consent of everyone being filmed. There's really no distinction because the sign on the lobby of the police department says you do not have our consent to record here, period. For the expectation of privacy of those reporting crimes, you're not here for a legitimate public purpose, even if you claim to be here for a public records request. If you're filming audio or video, because we care about people reporting crimes on sensitive things like sexual assaults, domestic abuse, all that matters. We are sensitive to that. The Sheets versus Punta Gorda case specifically says, was Sheets, who was recording without consent in City Hall there, said that the city inside of a government building may at times be open to the public, but it's done so for the purposes of legitimate business established by the city itself. And the city may limit the use of property to ordinary conditions for its intended purposes. And the court says, put it simply, Sheets, who was the person challenging the ordinance there, nor any other person has the absolute right to visit City Hall. So when the city limits its use of City Hall based on a violation of ordinance, it's not violating liberty interest. No one has the right to be in a government building except for the purposes for which the government is giving the public access. This is not the same thing as a public sidewalk or a public park or an interaction with a law enforcement officer during a traffic stop. That's a completely different analysis, a form analysis. There is a reason why those cases hold what they hold. With respect to law enforcement videos, I mean, that is completely different. First of all, if there's a public records request made, those value cam footages and are subject to public records exemptions, confidentiality exemptions. We have no way of protecting members of the public if a private party comes in and audio records let's say a spouse who's reporting a domestic battery. Once the private person has that video, it's posted, live stream on YouTube, recorded. It is an invasion of that sensitive situation, and then no way of controlling it. You know, think about it. We go in government buildings all the time. What are we subject to? We're subject to going through metal detectors, searches. Where's the claim that's unconstitutional? I mean, it isn't. It's a government building that has a purpose, and you are subject to the rules, reasonable rules of time, place, manner restrictions when you enter that government building. When you go to a government meeting, you are restricted in your speech in many ways. You may not like it, but you cannot just get up in the middle of a meeting and make commentary at your whim and disrupt the proceedings. With respect to public records requests, the city has afforded Mr. Gray and others multiple ways of obtaining public records. You can't just say, well, I am here for a public records request, that's why I'm filming, I need to document that I'm doing a public records request. That isn't if you really want a public records request, we have a public portal. Use it. Call. To use the telephone. Obviously, he's got a smartphone. It has the capability of using the internet and serving as a telephone. We're not trying to obstruct public records requests. In fact, Your Honor, you'll see in the video that Sergeant Gillum went above and beyond what he was required by law to actually, once he left the lobby, take Mr. Gray's public records request, even though he's not the custodian of records. He was so accommodating to Mr. Gray on that. There was no interruption in his ability to get public records.
He never submitted the request for this is submitted one of them. So maybe we should just bullshit everybody, huh? So he might have been accommodative, but he didn't do his job.
So Mr. Gray has a YouTube channel, and that, I guess, the way he makes his living, fine. You know, this is America, do what you like. But the way he does it, he's disrupting the public business of that lobby.
Okay, Mr. Graham, I'm going to ask you, I know you have your opinions, but you got your time, without interruption. I want to let Mr. Langley, this is your closing arguments.
He's lying a lot, though.
I hear what you're saying. If you want a minute when Mr. Langley finishes to respond, or a couple minutes, I'll be happy to let you respond. Okay?
I appreciate that.
So anyway, let's go back to the Sheets v. Punta Gorda case. I think if you read that case, you'll understand that the government has the right time, place, manner, restrictions upon First Amendment, otherwise First Amendment activities inside government buildings in order to constrain the activities in those buildings to what the city is allowing access for. And the Middle District Court in that case clearly found that you can, in fact, prohibit audio-video recording without consent. This ordinance and these signs say you don't have consent to record in this lobby. That is a limited public forum solely for the purposes for which the city has invited the public. Once you are there for purposes of violating the ordinance, you're no longer considered under the ordinance to be there for a legitimate public purpose. So no, you cannot do two things at one time. You cannot violate our code and ask for a public records request pursuant to our ordinance. That does not comply with our ordinance. So once you cease just being there for public records and you actually violate the ordinance before you ask for the record, that's really what the facts show. He was there first to violate the ordinance and then using the public records request as a guise, a ruse, to try to claim that he was there for a legitimate public purpose. But even after it was well established that he was not there for a legitimate public purpose, the city accommodated him in what might have been maybe a legitimate public records request. And even if it did not, the officer involved was not the custodian of records, and Mr. Gray can do all the records requests he wants via phone, via his public portal, and we're happy to accommodate that. So again, this comes back to what I said in my opening. Clearly established violation of the ordinance is not even disputed based on the facts and stipulations. Trespass warning was properly issued. Clearly and convincingly, the evidence shows that This appeal has no merit, and this was just an opportunity for Mr. Gray to grandstand on his YouTube channel. Thank you.
Mr. Gray, if you'd like to respond to anything stated by Mr. Langley.
Sure. I don't want to grandstand, I just want to get right to the point. But Mr. Langley mentioned that Sergeant Young wasn't the custodian of records. Florida statute, chapter 119, you don't have to direct your records request to the custodian of records. Any officer can take the records request. It's codified in the law. He gave me a bunch of ways that I can go and make my public records request. Well, one of those ways is in person. You don't get to tell me that I can't do a certain way because you don't like the story that I publish about the city. If Sergeant Young had just came out and taken my public records request, I would have walked right out of the office. In fact, Sergeant Young wasn't even necessary for any of that. Had the lady at the window simply taken my public records request, we wouldn't be having this conversation. I've done that plenty of times. I've gone into that office, I don't know, no less than 5 times requesting records. And Mr. Langley makes the assertion that Young went out of his back, he bent over backwards to do this public records request. Well, he only submitted one of the records. I must have stood there for 15 minutes in the baking sun, outside, hot as HE double hockey sticks, boiling, because I couldn't do it in the air conditioned, I couldn't ask my questions in the air conditioned public lobby. It's outrageous. And then to say that, oh, I bent over backwards, he didn't even submit the records request. I got a message for maybe 2 of the questions that I asked. We want to make accusations about what I'm not doing in there is legitimate business. Well, we don't really know because my records weren't fulfilled. We have no idea what I was going to do with those records. I guess we could just sling some mud, though, and say that, oh, we bent over backwards for Mr. Gray. Well, no, I don't think so. In sheets, again, to just hammer the point home on sheets, the Punta Gorda ordinance allowed the video recording. It didn't say that you couldn't video record. They even admit you have a right to video record. They're just saying, if this member here, if this member there says that they don't want to be recorded, that they can object to it. Now, I think that's outrageous too, but at least we need to frame the case around the facts, which is Sheets affirmed the right to record. It didn't say you can't record, no recording. It said you can record. You just can't record somebody that doesn't want to be recorded. You can't record without... I'm not sure, I'm blanking on the word, but you need permission basically to film. Consent is the word in the ordinance, consent. Well, consent is if you move here, you don't even have an opportunity to exercise your constitutionally protected rights because they've just outlawed it. And if you want a copy of your record, then you got to pay for it. If you want a copy of what happened in that public lobby, that open public lobby, open to the public during business hours, you've got to pay for it. Doesn't seem neutral. Thank you, Your Honor.
Thank you. Anything else? All right. Well, I want to thank both of you very much. Important questions to address at 11:30. If with that, we'll conclude. I'll be looking forward to getting any case law that anyone wants to submit to me. Again, from Mr. Gray by Monday, hopefully. Mr. Langley by Friday. If something comes up, if you need additional time, please do a request in writing. Make sure the other side's copied on that. And then I will promptly rule within 5 business days after I have all the materials.
Thank you, Your Honor.
All right, thank you. All right, have a nice day. Have a nice weekend.
You too.
Who goes by this is a public service on YouTube.
This is a public service.
This is a public service.
We're out here today to ensure our natural rights are respected by those who swore an oath to support, protect, and defend the rights of the people. The purpose of all interactions is to peacefully promote government accountability and transparency. Please like, share, and subscribe so this message can reach as many people as possible. I implore you to peacefully seek redress to any and all of your grievances. This is a public service.